Good morning, ladies and gentlemen. Welcome to our online training. My name is Sabina Strebowski. I'm the head of European and International Organizations Office, Foreign Affairs Department within the Chamber of Commerce and Industry of Romania. Today, I have a pleasure to moderate this training dedicated to the intellectual property protection in China. Before giving the floor to our distinguished speakers, allow me please to recommend you, dear participants, to address your questions in chat, questions that will be approached after presentations during the Q&A session. Without further ado, I'm pleased to invite Mr. Eduard Costin, Director of Foreign Affairs Department within the Chamber of Commerce and Industry of Romania, to present his welcoming speech. Mr. Director, please, you have the floor.
Good morning, everyone. Thank you very much, Sabina. Good morning to you all, my friends. I'm really very pleased to welcome you all to today's training. The Chamber of Commerce and Industry of Romania is pleased to act as a partner for China IP SME Helpdesk, and I want to use the opportunity to convey my sincere appreciation for your work. This work aiming to support today the Romanian SMEs that operate or intend to access the Chinese market and help our companies to improve their global competitiveness. The intellectual property is an important business asset for each enterprise, no matter of its size, as it provides with comparative advantage over competitors and protects the company's innovations. Knowing the value and implications of intellectual property rights is essential for the short, medium, and long-term strategic decisions of a company. Considering these, our partnership with China IP SME Helpdesk aims to offer you, dear participants, dear entrepreneurs, all the necessary information about the steps that must be taken if you intend to make trade with Chinese partners. Given the specific activity of the Chamber of Commerce and Industry of Romania, I would like to mention that in the last few years, we saw a high interest of both Chinese and Romanian entrepreneurs for doing business together. At this moment in Romania are registered over 13,000 companies with Chinese capital. Our chamber, together with the county chambers of commerce, have organized a range of bilateral economic forums with entrepreneurs from several Chinese provinces such as Shandong, Guangdong, Fujian, Zhejiang, and Shanghai municipality. The results of our efforts, we believe, can also be seen in the current bilateral trade figures. Last year, for instance, the Romania-China bilateral trade reached the value of 5,890 million euros, of which 829 million euros represent the Romanian exports. The balance is clearly and visibly negative for our country, for Romania, and this is probably the situation for most of the European countries. And this is a reason for which I would encourage the Romanian entrepreneurs to explore this market and to find ways to export more on the Chinese markets, because it's a huge market which can absorb a lot of our products. Last but not least, it is relevant to mention that in 2020, China was the fourth import trading partner of Romania, representing 6.3% of its total imports, and the 17th export trading partner, representing 1.3% of Romania total exports. In closing, I will say, ladies and gentlemen, that I really wish you all a pleasant and insightful time with our distinguished experts and friends, and I wish you good luck in your future endeavors to access international markets. Thank you very much, and full success to today's event. Thank you.
Thank you, Mr. Director, for your speech, reflecting so well the Romania-China bilateral trade relations. The next speaker I would like to invite is Mrs. Alessandra Caprilia, Project Executive of China IP SME Helpdesk, to briefly present some information about the activities and services they provide to European companies and the way they can help you. Please, Alessandra.
Hello, everyone, and thanks a lot to the Chamber of Commerce and Industry of Romania for co-organizing this event with us. It is a pleasure to work again together with you. So yes, I am Alessandra Capriglia, Project Executive for the China IP SME Helpdesk. The Helpdesk is an EU-funded project since 2008, providing free initial advice to SMEs, so advisory services to SMEs interested in China in relation to intellectual property protection and enforcement. We not only cover mainland China, but also Hong Kong, Macau, and Taiwan, each of them having a particular legal framework. Over the last almost 13 years, we have helped over 100,000 SMEs, not only from European Union, but also from potential future member states such as Bosnia-Herzegovina, Montenegro, Turkey, Serbia, and so on. Our most important service is, of course, the inquiry helpline, which is an email address to which companies can write and submit all their questions related to intellectual property protection and enforcement in China. And for those companies that are already in China and they find out any infringement or violations, they can contact us to get some initial advice on what's best to do in those cases. Together with intermediary organizations such as chambers of commerce, trade associations, embassies, and so on, we organize trainings and workshops and webinars like today. With focus, today we're going to provide an overview of the IP legal framework. Sometimes we cover specific aspects of intellectual property and sector-focused content. On our website, you can find a variety of materials, for example, guides, regional fact sheets, and case studies, real case studies, that are free, of course, to download for everyone. These are two examples of what you can find on our website. On your left-hand side, there is the China mainland fact sheet, providing an overview of the legal framework of the market in terms of IP. And on the right-hand side, you can see a guide for technology transfer. The China IP SME Helpdesk is part of a big family of IP helpdesks, all projects of the European Commission, providing all of them the same services but covering different regions such as Latin America, Southeast Asia, India, and the European region itself. So welcome to contact them. We are now under the same roof in the European Commission website. So welcome to visit the website and get to know a little bit more about our services. Welcome to stay connected with us, to follow us on our social media, where we post about our events, initiatives, new regulations in China, and also our new publications. And on YouTube, you can find recordings from past webinars. And once again, the helpline is our most valuable service for SMEs. It's a direct channel for companies, for entrepreneurs. So feel free to contact us. And of course, welcome, as Sabina said, to write down all your questions today. And our expert, Tom Carver, will be happy to answer. And thanks again for today, and enjoy the training.
Thank you so much, Alessandra, for this useful presentation. Now I have a pleasure to invite Mr. Tom Carver, partner at Gunnar Cook, expert in intellectual property with substantial experience in multiple jurisdiction patent and design rights litigation in the UK and in China. Please, Mr. Carver.
Thank you for the introduction. And thank you for inviting me to speak. It's a shame that we're not allowed to travel and we can't be doing it in person in Bucharest. But I suppose the webinar is the next best thing. But yes, it would have been nice to be meeting you all in person. I've been on the China Helpdesk for 6 or 7 years, I think. I used to live in Guangzhou in South China, where I was the head of the the Guangzhou office for an English law firm called Ragg Lawrence Graham. So I spent 3 years in China enforcing IP rights for Western companies. So I'm just trying to get on to the next there. Advising Western companies on their IP in China. So between sort of 2011 and 2014, I was living in China on the coalface, as they say, really getting into it. Obviously not. So in China, foreign law firms are not allowed to practice Chinese law. So we sort of worked through Chinese law firms and acting effectively as the intermediary between the European and US clients and the Chinese lawyers. So I had a lot of experience. Advising Dyson was one of my main clients. They sued an awful lot of people in China. We'll come on to that in a minute. So I was asked to give a sort of general overview of IP in China and what sort of thing you should be looking out for when you're looking to sell into China. So I'm sort of doing the talk as a kind of on a timeline. Actually, we'll address things as you would come across them when starting to sell in China in the same sort of chronological order. So give a sort of brief outline and then a few case studies, stories of the mistakes I've seen companies make when they're starting to look at China, or indeed have been in China for quite a long time and they've still made these mistakes that you should try to avoid. So the initial problems, which almost everyone comes across, is trademark squatting and the sort of equivalent problem for designs. So you'll find that any trademark that's remotely famous may already have been registered in China. And this is sort of allowed to happen because China is what we call a first to file jurisdiction for trademarks and design patents. A design patent is effectively the same as a community registered design. So they in China, they refer to designs as patents. They have design patents, utility patents, and invention patents. Invention patents being the same as our, what we would call a patent. But coming back to trademarks and designs, there is, I don't know what the situation is in Romania, but certainly in the UK, you can have sort of unregistered rights in a trademark. You can have goodwill in your trademark, and that can give you some protection. But in China, that's not the case. It is absolutely the case that the first entity to file for a trademark is the owner of that trademark. And there's very limited protection for unregistered rights. There's something called the anti-unfair competition law, which I did use successfully once, but there was a very unique situation. There was a mobile phone brand called Vertu a while ago. I'm not sure they still exist, but an enterprising Chinese shopkeeper had created an entire Vertu shop in a city in China, completely unauthorized, and we managed to. And they were selling Vertu phones, but apart from that, they were entirely unauthorized. And it happened with Apple as well, actually. These Apple shops springing up that were not official Apple shops, but they were selling Apple merchandise and they were holding themselves out as Apple shops. And you can use the anti-unfair competition law against that sort of big thing, but not against just trademarks that have been registered by someone else. So what do you do if you get there and you go to register your trademark and you find that someone else has already got it, or your design patent? Well, you can apply to cancel trademarks, similarly to in the EU for non-use, or if they're bad faith registrations. But the problem with that is non-use. You've got to prove that they have had non-use for 3 years. So you could be in for a long wait if the mark has only just been registered. and in that time, you are at the risk of being sued by the entity that's registered for your trademark, and if you do nothing about it. And bad faith can be used to, you can allege that the mark is registered in bad faith and have it cancelled. That used to be extremely difficult to do, because you used to have to prove that there was actual sort of a link between the entity that had registered your mark and you. So you had to show that it was an ex-employee or an ex-partner who knew about your trademark. Now they changed that so that all it requires now is for you to prove that it's a malicious registration with no intent to use. But it's still a difficult path to go down to have that mark cancelled. So really, it is best to make sure you're the first to file and you don't come across this problem. I mean, the other option, of course, is to buy the trademark from the trademark squatter, because that is, after all, their business model. That's what they want you to do. They file these marks so that when European companies or US companies come to China, they have to, they'll pay you an amount of money for your trademark. And Apple famously had a problem with that. They had to pay $60 million for their iPad trademark in China. That's obviously an exceptionally valuable one. So a case study of a company that had a problem with this, who came for a bit of advice from me when I was there, is a watch company. I think they're a Belgian watch company. And they made a lot of watches, 400,000 watches per month they were making in Shenzhen. So, they were really quite established and a big company, but they had no IP rights registered in China at all. I mean, it was extraordinary. They had no trademark, no design rights, nothing. But of course, when you're that big and that famous, there's going to be infringements. And there were large numbers of counterfeit watches being made and sold in Shenzhen. And when they tried to register their trademark, they found that someone else had done so already, unsurprisingly. So, what could they do? Well, this was pre the change in the law that allowed you to cancel a mark for bad faith if it was a malicious or no intent to use. And so they couldn't prove bad faith registration. They couldn't use the anti-unfair competition law because it was too sort of small and not a chunky enough case. And also, to use the anti-unfair competition, you have to prove that you have goodwill, reputation in China. And these watches were all for export. They were all sold in other countries in the world. So they couldn't prove that they had any reputation in China. And they could have tried to apply for the mark to be cancelled, but that would have been extremely slow and taken another 3 years. So, they were pretty stuffed, and they had to just essentially sit and watch these vast numbers of counterfeits being made and sold, eating into their market in Shenzhen for 3 years, while they waited for the non-use period to expire, and then they could apply to cancel it. And this was a bizarre situation, because it could have been avoided so easily had they registered their mark a bit earlier. A tiny sum, really, for a company of that size. I mean, I appreciate if you're a startup company, then it's a bit more significant. But for a company of that size, 600 euros, and they could have solved this problem and stopped the counterfeits. And so it was a fairly salutary lesson for them. So that's the first thing to say, really, is you must be aware that it's a first to file jurisdiction, and you must file early. And way earlier than you might think. I mean, these trademark squatters, it is their business model. So they, they sort of trawl the internet looking for brands. They trawl the European registrations looking for brands to register. So as soon as you sort of start to come on their radar, then there's a chance that they will register your mark. So you've got to be pretty quick off the mark. So that's that tends to happen before you even get there. And then what happens when you start to sell in China? Well, they say that imitation is the most sincere form of flattery. And while that may be true, it's not always a good thing. But I'm afraid the price of success in China is that there will be infringements. purely because IP enforcement in China is so weak, or has historically been so weak. The sort of, the cost benefit analysis is very much in favor of Chinese companies copying foreign brands, foreign products, rather than creating their own. And this can, it can be, as I said here, the numbers can be dizzying. I mentioned earlier, Dyson was one of my main clients. Their bladeless fan, I don't know if you have these in Romania. They're not very popular in England, but they're very popular in Asia. And it's a desk fan that has no blade, and they're incredibly easy to make. It's just a bit of plastic molding and a motor. And that sort of combination of something very easy to make and something very popular caused this sort of explosion in infringements. Hoverboards were another example. A couple of years ago, they were tremendously popular Christmas presents, and they, the numbers of companies that will start infringing your successful product is remarkable. Remember, China is a huge place. There are many, many provinces, many companies. So you've got to, so effectively, your first problem will be people registering your designs and trademarks before you. Your second problem, assuming you're successful, is that people will start copying you. It might be third parties who just want to copy you. It might be your own distributor or your own manufacturer, if you're manufacturing out there, or indeed your own customer. And how can that be? Well, for example, architects. I used to act for Zaha Hadid, the famous architect, and she found that she'd do one design for a building, and you'd find multiple buildings made to the same design in different places, or for example, single software licenses being used multiple times, and that leads me on to my next example. My next case study was a client I had who were a US-based special effects company. So what they did, they made the hardware and the software for special effects in theatres. So the sort of ropes and pulleys and one thing and other to enable an actor or a bit of set to fly across the stage on a rope. And they made the ropes, but importantly the software to control the speed of movement of the actor on the rope or whatever it was. That was the really important bit with this software. And they had met with and agreed a deal with a large Chinese company called Wonder, who were planning to build a number of theatres in the country. And they agreed a deal just for one theatre as a sort of a preliminary step. And so they made, verbal agreement with the parties meeting together. And they then all went away, and the Chinese party drafted the contract and sent it over for a review. And this is the IP clause that was in that contract. It was slightly oddly worded, that if the owner needs to use seller's intellectual property, so owner being the Chinese party making the theatres, seller being the US client, needs to use seller's IP for the purpose of application for or use of the above mentioned new IP rights, the seller agrees that the owner or its associated companies may use their intellectual property rights free of charge. Now, that to me looks like a perpetual royalty-free license to all of our clients' IP. This is the seller agrees the owner may use their IP free of charge. So we thought that was a bit odd and not really what the parties had agreed in the meeting. And so we responded with a narrow clause as a license just for a single theatre, single use. But the Chinese party came back and said, no, it's their wording is absolutely perfect and it reflects the verbal agreement, and they wanted to keep it. So, but we, US client didn't like that, so they dug their heels in, and I went off to have a face-to-face meeting with the Chinese party. And we talked for a long time, for hours and hours, mainly about this clause, about what the parties were trying to achieve. And eventually the Chinese party they accepted that, yes, the clear meaning of that clause was a perpetual royalty-free license to all of our clients' IP. And that is, what they wanted, because they wanted to build many theatres and they wanted to use this software in all their theatres. But the US party had, the pricing was only for one theatre. So the client abandoned the project and pulled out of that completely. And so, this is just a sort of a case study on language, I suppose, and making sure that just because a clause is oddly worded, don't be persuaded that maybe the Chinese version of that clause is narrower and more to your liking, because normally contracts will be in both languages. It's normally, when you're doing a contract like this, you'll have a bilingual document with the same clause in Chinese and English or Romanian or whatever language you're working in. And so it's important to make sure in those cases which language is the dominant, this is the controlling language, and also to make sure that the translation is correct. And when you come across these slightly oddly wording phrases, you need to make sure that it is saying what you want, and not to be sort of persuaded that it's just a poor translation or poor wording or whatever. You must insist on properly drafted contracts which reflect absolutely what you are looking for, because it's very easy to be sort of swept away with this prospect of a huge market and a great deal and a whatever, and go along with a bad contract. So that's second point to note. So then, once you're established in China, you've started selling in, you've registered your trademark, made sure your contracts are watertight, or then a bit more firmly ensconced. It's very important to keep monitoring the marketplace, because, as I said, infringements will sort of appear, and you want to act fast when you spot one. It's much easier to if a Chinese company is starting to copy your products, then the chances are at the beginning, they won't spend very much money on tooling or molds or, whatever it is that they need to make your product. They'll just sort of dip their toe in the water and maybe buy the parts from someone else, put it together, just sort of assemble things rather than manufacture. And at that point, they've not invested very much into their new line. And if you can attack them at that point before they've invested, then you're going to be much more likely to persuade them to stop than if you leave it for a while. And they after a few months they haven't been sued, no one's approached them and said that this is illegal. They will be a bit bolder and maybe invest a bit more money in the venture. And once they start investing more money in it, then they're going to be much more reluctant to stop, because they would have had this sunk cost, which they don't want to waste. So it's very important to keep monitoring the marketplace. You've got to patrol trade fairs. So there are trade fairs all over China, which are less important than they used to be now, because things are moving online, but they're still very important. It's still a huge marketplace for China into not just the West, but African, South American markets. Or there's the Canton Fair in Guangzhou, where I used to live, is twice each year for 3 weeks. So there's a 3-week fair twice a year, and it's vast. I mean, there's I can't remember how many football pitches worth of stalls there are, but it's sort of 15 or 20 football pitches size of stalls for 3 weeks twice a year. So it's enormous, and there's a whole hotel trade in Guangzhou that only these hotels only open for those 6 weeks when the fair is on. It's that big a deal. So and there's, you know, in the Canton Fair it's fairly sort of general. So 1 week of the 3, you know, each week deals with different industries. But then all around China there are more industry specific fairs. And it's very important to go to these fairs because this is where, you know, products first get marketed by the Chinese companies. So you need to go and you need to make sure to see if anyone is starting to market products that infringe your rights. So those are the in-person, in real life fairs, and of course there's also Alibaba and Taobao, which are, as I'm sure you know, the equivalent of Amazon and eBay in the West. And it's very important to monitor these because these are equally important marketplaces. You know, it's quite easy to do. You just have a, you know, get an intern or a trainee of a Chinese law firm to spend an hour a week or something, or an hour a month, going through using various keywords, searching for your products. So it's inexpensive and well worth doing so that you can find new infringements fast. And of course, customers, your customers are a very good source of feedback, because if you're, you know, your sales team should always ask your customers what the market's like, and they will know if someone else has been offering products that are very similar to yours. So that's monitoring. What should you do? Sorry, was that a question? So what do you do when you find infringements? There are various options depending on where you found them. There's civil litigation, which is the equivalent of litigation in Europe. So this would be for the sort of larger cases. It takes something like 6 to 9 months, and you can get an injunction. You can get asset and evidence preservation orders. So I'll come on to those in a moment, but effectively an asset preservation order is seizing, it is freezing bank accounts belonging to the infringer so that they can pay any damages order that's ordered. Evidence preservation order is seizing evidence, so you can have a judge visit the factory where you believe infringing activity to be taking place, and they will take photographs and take evidence. And again, I'll come back to that in a moment. And civil litigation, I mean, it used to be terrible. It's improving. They have specialist courts. They've had specialist courts for a few years now. A couple of years ago, the Court of Appeal was changed from the regular Court of Appeal to the Supreme Court. So all appeal cases in IP now go straight to the IP tribunal, the Supreme Court, which is an improvement in that there's much more consistency. There used to be a problem of inconsistency between provinces. You know, the Guangdong courts would not necessarily order the same kinds of remedies as the Shanghai court or the Hunan court. So it is quite effective for trademarks, for designs. Invention patents is you need to be a little bit careful litigating invention patents in China, because there's a political element to it. But usually for trademarks and designs, you'll be fine. Administrative litigation is a bit more like sort of trading standards. I don't know if you have that in Romania, but it's kind of much more local government enforcement rather than judicial enforcement. So it's much faster. A case can take just 6 weeks, and they are empowered to give to grant an injunction, but no damages. They will only levy fines. So you, as the rights holder, won't get any benefit from that. The fine is paid to the local government, but of course you get the benefit from the injunction. Trade fairs, you can enforce at a trade fair. So as I said, you should be monitoring. You should send representatives or go yourself to trade fairs to make sure that there are no infringing products being marketed. If you do find infringing products, then it's possible usually to have the products removed from display. But I'll come on to that because it's not quite as simple as it sounds. You need to be prepared to a certain extent. But if you fail to get the products removed, you can at least take some evidence. You take the notary public along and gather some evidence of the sales. And obviously, you will then have your own more information about your infringers. So online, Taobao and Alibaba have relatively good online enforcement systems. So if you register your rights, you should be able to have infringing products removed from Taobao and Alibaba. Customs seizures. These are quite good. So the Chinese customs for exporting products are quite proactive. They're quite enthusiastic. So if you know that some products are being exported, you can have them seized by the customs and they'll be impounded. You then have to bring a civil litigation as a follow-up to prevent the products being released. So once you seize them, the infringer can pay a bond and have those products released. And you then bring a civil litigation, but at least the bond is, the money is there in a bank account that you can enforce your damages award against. So the first time you do it, the products might still be released and still be exported to the country where they're going. But we found it, when I was working with Dyson, as a very effective deterrent to further exports, because you have that money in bond that they have to pay to export, and then you can bring your civil litigation and take that money as damages. And so it's quite an effective way of ensuring that damage is paid, because often damages awards are not paid. And it's quite a sort of, embarrassing for the Chinese company. It's also quite difficult to do, because the customs officers, they're keen, they're enthusiastic, but they also need very specific instructions. So you need to tell the customs officer which ship the products are going to be on. You need to tell them the number of the container that the products are being carried in, and you need to tell them the exact day that these products are arriving into the port. So all of that takes a bit of organising, because to know the number of the container, you need to have a mole in the factory where they're producing these products, who can tell you when the products are being loaded into the container for transport to the port, and tell you the container number. And then sometimes you find that the products get switched container en route, so you then have to have an investigator, a private detective, following the container from the factory all the way to the port in case they pull over and switch the products from one container to another. So that all costs a bit of money, having a mole in the factory for maybe a matter of weeks or months, and then having an investigator tailing the container from the factory to the port can all take money. But if you have a significant infringer who is exporting significant amounts of product, then it's well worth doing, because even if you can't attack them in China, at least you can prevent your products being exported. So those are the sort of main enforcement options. I've got a case study of at a trade fair, because trade fairs can be quite effective, but you do need to be quite well prepared. So I had a client who was a luggage company, and they had come to the Canton Fair to source parts. They wanted to, get new wheels or something, new zips for their products. And they came across stalls by accident. They weren't patrolling, they weren't looking for infringements, but they came across stalls exhibiting products identical to their own products, which surprised them. And it turned out to be their own manufacturer, their own Chinese manufacturer, that was selling products on the site. And this is very common. You frequently find factories, Chinese factories, will produce for the Western clients during the day, and then there's the sort of night shift. Everyone will go home, wait for the European manager to go home, and then they'll all come back to the factory and work at night in the same factory using the same machines and everything, to produce another batch of product that they can sell on the grey market, black market. Anyway, so that's quite common. You need to watch out for that. But in this instance, they were at the fair. All these products were there. So what could they do? Well, the problem was they couldn't actually complain because Chinese bureaucracy is very rigid. They invented bureaucracy, paperwork, and they're very keen on it. And so for any sort of legal action, there's quite a lot of paperwork that needs doing. I mean, I don't know how much you need in Romania, but in England, we don't. There's not such a great bureaucratic need, but in China, there is. You need to have a number of documents. You need to have your certificate showing of your right. So you've got to take your patent certificate or your trademark certificate, whatever it is. Not only that, you've got to have take a receipt showing that you've paid this year's fees and that the certificate is still extant, that it hasn't expired. So you've got to have that, but then you've also got to prove that you have authority to make the complaint. So if the IP belongs to a company, you've got to have the certificate of incorporation, and you've got to have a power of attorney. If it's a lawyer making a complaint, you've got to have a power of attorney from the company to the lawyer. If it is an individual making a complaint, so if you're there as an individual, you've got to representing a company, you've got to have a certificate confirming that you're an authorized, effectively a power of attorney from the company to you. And then you've got to have your own ID. So you've got to have this chain of documents showing that who you are, what your authority to complain is, and that the owner of the IP exists, and that the IP exists and is fully paid up. If the IP holder is an individual, then you need to have a similar sort of chain of evidence. So, this does require a bit of organizing. So when you're looking to patrol trade fairs, if you're monitoring the marketplace and you're planning to patrol, you've got to make sure before going that you have all these things. You've got to make sure that your patent is in force, and you've got your receipt, and you've got your power of attorney and certificate of incorporation. And that certificate may need to be notarized at the Hague apostille to prove its authenticity. And these things can take weeks or months to organize, depending on how efficient the Chinese embassy is in your home country. So it's very important to sort of be prepared for this sort of thing. And likewise for litigation, you can source documents for that too. But this luggage company had none of that. So that was unfortunate for them, but it wasn't a total loss because they could gather evidence. So we called a notary public, Chinese notary public, to come visit the fair, and that notary public took pictures and gave a statement about the infringement, and we can then use that statement in evidence after the fair is over. You can go and sue that company. You can use that evidence to establish jurisdiction. So you might find that the company is based in a province where IP protection is weak or poor, and you would rather sue them in the province where the fair took place. So if you want to sue them in Guangzhou, for example, you might be able to use that evidence of their exhibiting in a trade fair in Guangzhou to move jurisdiction from their home province into Guangdong. You can also, the other reason for taking evidence is to increase the damages award. So damages for infringement in China in theory are the same as most of the rest of the world. You can either recover the patentee's loss or the trademark holder's loss, or the infringer's profit, or in China's case, you can also get statutory damages. Now, 90%, at least 90% of cases wind up with statutory damages because it's very, very difficult to prove your loss, and it's very difficult to prove the defendant's profit because of the rules of evidence. And so generally, you end up with statutory damages. And if you have this, the more evidence of infringement you can produce, the higher you can persuade the judge to award your statutory damages. So, getting evidence from a trade fair can be used for that. I've had very sort of specific case studies, and people often still think, well, is it really worth suing in China? Is it, they're so big, there's so many infringers, it's such an onerous undertaking. Is it worth doing? So I usually, like to give an overview of what can be achieved. And I mentioned these bladeless fans that Dyson had problems with. And they're quite a good example. I mean, the copies started appearing very quickly in China after Dyson launched them, 4 months, it says. And this, as I said before, is because they're very easy to make. It's just a bit of plastic molding and an electric motor, and they're very popular. So these, it started appearing immediately. And in the year following launch, there were over 1,000 instances of infringement outside China. They're all Chinese made, but 1,000 instances were reported. So Dyson obviously, kept tabs on all the infringements around the world, and they had, ongoing issues in South Africa, in Latin America, in the US, Canada, all around Asia. They monitored everything. And there were, over 1,000 in the first year. So it was a huge problem, and it was Chinese infringement was eating into their profits outside China massively. So they came to us, and we had this quite extensive campaign. I think we sued around 150 companies in the first year, and we patrolled the trade fairs, and we did the online marketplace patrolling. We did customs enforcement. We did the full everything that we could do, and as you can see, it was very successful. So after 2 years of this campaign, infringements outside China had fallen to around 100. So that's 10%, isn't it? So a significant reduction. The bottom there still. So we did English keyword searching on Alibaba, but we didn't do Chinese. I think because non-Chinese companies, so if you're Korean or you're South African or Brazilian or whatever, and you're looking to buy on Alibaba, you'll be looking in English, not in Chinese. So we didn't do Chinese keyword searching on Alibaba, and there were still 40,000 adverts in Chinese. That gives you an idea of the sort of scope of the scale of infringement that we were dealing with. So it was it's a successful campaign. It's a very good example of how you can, if you take the right steps, protect your markets outside China very effectively. And there are, difficulties. So in practice, the rules of evidence in China are very strict. The Chinese courts' sort of default position is that they don't believe anyone except for a Chinese notary public. So to obtain evidence of infringement, you must have a Chinese notary public conduct a trap purchase. He's got to sit down, or she, at his or her own desk and order the product on a computer so that it hasn't been tampered with, and then write up a report saying that they did it. So that presents problems. You can, as I mentioned earlier, have an evidence preservation order. So you can ask a judge to go to visit the factory where you believe infringing products are being sold. And you might want to do that because you need evidence of a process, if it's a process patent that you're looking to enforce. Or you might want to do it to get an idea of the scale of infringement, so to increase your statutory damages award. But even this can be difficult. I had a furniture client, and we got an evidence preservation order from the court, and the judge went to the factory together with our lawyers. But the by way of example of how weak the judiciary is in China as compared to the local government, the owner of the factory has simply refused to let the judge in. They just bolted the doors and refused to let the judge in. So that even though the court had ordered that an evidence preservation order should be carried out, we couldn't do it. In that case, we called the local mayor of the town and said, explained what was happening, and he came and forced the factory owner to open the door. But it doesn't make it easy. So settlements, generally in China, cases will the judge will try to settle cases rather than give a decision for various reasons. Get through their caseload faster to avoid having to give a decision. And usually it's good to get a settlement rather than a court order against an infringer, because an infringer is generally more likely to comply with something that he has agreed or she's agreed than with an order that's given by the court. So often, while it can, it feels counterintuitive or feels unsatisfactory to be settling, often you get a better result. And a settlement can't be appealed. So next point, appeals now go to the Supreme Court, but if you settle it, it can't be appealed. Interim injunctions are very, very difficult to get in China. Rules have changed to make it slightly easier these days, but you need to prove irreparable harm. And the Chinese court's view has always been that damages are a sufficient remedy, and therefore there is no irreparable harm. That doesn't apply to recent cases in which interim injunctions have been granted are things like trade secrets. So the courts do accept that if a trade secret is leaked wider than the immediate leak, then that is irreparable harm, because a secret, once it's been released, can't be put back in the box. So it's more easier to get an interim injunction on something like a trade secret than it is for a patent or a trademark infringement. Enforcement, as I said, it can be difficult. The judge might not be let into a factory if you're trying to enforce an evidence preservation order. Trying to get damages awards paid can be difficult. The parties will just ignore them. So damages, as I said earlier, tend to be fairly small. So generally you'll get a statutory damages award, which bears very little resemblance to the damage that you might have suffered. But it's better than nothing, and if it's paid, then that's fine. The law has changed to introduce punitive damages for severe or willful infringements, and you can now get 5 times the standard statutory damages award in cases of severe or willful infringement. But again, you might not actually get it paid. So civil litigation, it can be done, and sometimes it can be very effective, but don't expect it to be an easy ride. But it can be done, and if you do it properly, it can be effective. Administrative litigation, also can be very effective. It's much cheaper to do, much faster to do than civil litigation, but it varies tremendously between jurisdictions because it's local government, and they may not want to attack a big local employer, so you face that sort of political issue. So in summary, remember that China's first to file jurisdiction, so you've got to register your rights very early on. Remember that there is a language barrier, and you shouldn't be sort of flummoxed or tripped by that. Do proper due diligence, make sure your contracts do in fact do what you think they do. Visit if you're manufacturing in China, you want to go out and make sure that they're not, your OEM producers are not making stuff on the side. And you need to make sure that you're patrolling the various marketplaces and find infringements quickly, so that you can deal with it quickly before it gets out of hand, before the infringer has spent too much money, invested too much in the product, and more reluctant to do anything about it. And then you must enforce. And in conclusion, a lot of people say, well, is it worth bothering IPRs? And the answer is yes. You absolutely should, because if you don't, you can't do anything at all. Like the watch company, they couldn't do anything at all. So that's the first reason. The second reason is purely for, if you've got funding rounds or looking for investors, then you're in a much stronger position if you do have protection. And should you spend money trying to enforce? Well, it's very difficult to prevent infringement within China, but you can protect outside markets. If you're sufficiently strong on your customs enforcement and your general enforcement, then you can generally protect ex-China markets. Inside China can be difficult, and as I said, there were still 40,000 links in Chinese on the Dyson bladeless fans, which, it's difficult to do anything about something that expensive. So I think that is the end of my slides. So I guess now we have some questions and answers. Is that right, Sabina, Alessandra?
Yeah, thank you so much, Mr. Carver, for this information, for these concrete examples and pieces of advice on how companies can protect their intellectual property rights on China market. Now I would like to open the floor for questions. We don't have any question in chat, but we received some questions through the registration form. I will read the first question aloud. Is it possible to be shared a draft of non-disclosure agreement which can be used in relation with Chinese companies? This question was raised by a company working in the military public safety area.
So I think the EU SME Helpdesk has sort of draft template documents. Alessandra, is that right? On the website, there's sort of templates. I mean, normally, non-disclosure agreement, it's best not to use something that is too generic, too much of a template. You want to try to tailor it to your situation. So it's best to get specific legal advice on that. But I think there are templates on the SME Helpdesk website.
Yeah, if the company agrees on sharing their email, we can follow up for sure.
Yeah, of course, I'll put you in contact.
Great, thanks.
Okay, thank you too. The second question actually was raised by two companies. It is the following: how can we protect our website and our brand name from being used by Chinese companies?
Well, I hope I answered that in the talk. You must register your trademark very early, register your domain name early so that no one else can get it before you, and then monitor the marketplace and enforce against any infringers.
Okay, thank you. I would like to encourage the participants which are present, if they want to address a question directly, they can unmute their microphone and they can address the question directly. Okay, I have one last question. Actually, it is a curiosity of mine regarding the recent decision of European Parliament to freeze the ratification of the EU-China investment agreement. I would like to ask you in what way this decision will influence the protection of European investments and intellectual property rights in China. If there will be some changes in this sense, or
Tom, you're muted, I think.
yeah, we cannot hear you.
Sorry, yes, I was muted. I think there won't be, won't trigger any changes in Chinese law, but there have been recent improvements in the law, as I said, on punitive damages and on trademark bad faith cancellation issues. But it may improve the sort of political climate. I mean, a lot of IP enforcement in China, does depend on the political climate. As I said, if you're trying to enforce with administrative enforcement, it is a local government that you are looking to for help. And so, if there is a closer cooperation between EU and China, then it's going to improve your sort of political standing there. And likewise with patents, with invention patents, you might find yourself in a better position. But I don't think it's going to, it won't change the laws specifically.
Thank you so much. I guess that we don't have any other questions. Anyway, if you will allow me, I would like to share this presentation with the rest of participants which didn't succeed to connect today to this training. In conclusion, I would like to, yeah, please.
No,
Yeah,
it was just,
yes.
yeah.
Okay, anyway. Okay, thank you so much. Yeah, actually, I was going to write you also through an email to ask you directly this. I would like to thank you, Alessandra and Mr. Carver, for your time and your valuable contributions. Dear participants, if you would like to get in contact with Alessandra, you already have her contact details. So I would like to thank you all and to wish you a great day.
Thank you very much. Have a good day, everyone.
Thank you. Have a good day.
Bye.
Feel free to contact directly as well for advice.
Thank you.
Thank you.